This is Barry Wood. I'm the Assessment Division Director for the DLGF, and I'd like to welcome you on a cold January day to our presentation, our first webinar of the, or second today, but the first webinar of the year for 2025 on appeals in the PTABOA. Marlo mentioned, sound issues. If you do have sound issues, we've found in the past that it helps if you disconnect and reconnect. That typically will solve the problem. This continuing education webinar is good for 1 hour of continuing education credit. And as Marlo mentioned, sometime this week, by the end of the week, we will get a copy of the presentation out to you along with the continuing education form. So first, a disclaimer, the Department of Local Government Finance does not get involved in individual property tax assessments or appeals. And this holds true both for taxpayers and from assessors. Frequently we'll be contacted by taxpayers or assessors asking our opinion, and we will try and provide as much guidance and assistance as possible. But at the end of the day, we do not get involved in the individual tax assessments or appeals because that's handled at the local level. I'm not an attorney, so the following information should not be construed as legal advice, and any legal questions or issues should be directed to your county attorney. So today we're going to talk about the PTABOA roles and responsibilities, legislative changes, best practices, common issues and problems, and questions. And if you are a PTABOA member, we'd like to welcome you. We're glad you're joining us. So there are two types of PTABOAs, or actually sizes of PTABOA. Back in 2009, a special session of the General Assembly passed House Enrolled Act 1001, and that allows the county commissioners to determine if they want to have a 3-member board or a 5-member board. And this was effective July 1st, 2009. And some counties find that it's beneficial to have a 3-member board, especially if they have problems trying to find PTABOA members. Others prefer a 5-member board just because hopefully more expertise or more eyes, so to speak, reviewing and deciding cases. But it is a local control decision on whether or not the county would want to have a 5 or a 3-member board. And if we were to survey all 92 counties, I suspect we probably would see probably about a 50-50 split in regard to the counties that have a 3-member board or those that have a 5-member board. Another piece of legislation that was passed in 2016, Senate Enrolled Act 87, authorized the creation of multiple county PTABOAs starting January 1st, 2017. I am not aware of any multiple county PTABOAs in the state. If there were to be any, typically we probably would see, I would think maybe 2 or 3 or 4 counties, all geographically clustered in the same area. Say, for example, if we were to see up in the northeast part of the state, I could see maybe like LaGrange, Steuben, Noble, and DeKalb counties forming a multiple county PTABOA, or maybe down southeast part of the state, say Ohio, Switzerland, Dearborn, Ripley counties forming one. But I'm not aware of any counties that have actually taken the steps to create a multiple county PTABOA. For a 5-member PTABOA, the commissioners appoint 3 of the members, and the county fiscal body or the county council appoints the other 2 members. At least one of the members appointed by the fiscal body must be a level 2 or 3, and at least one of the commissioners' appointments must be either a level 2 or 3. However, both the council and the commissioners may waive this requirement. Members, what constitutes, or what should a member be, or what are the requirements? It's pretty simple right now. It just says members must be at least 18 years of age and, quote, knowledgeable in the valuation of property. There's no litmus test per se in terms of their knowledge, other than being, say, a level 2 or 3, and that knowledge, could be somebody on the board is an appraiser, somebody might be a realtor, whatever the case may be, but they are to be knowledgeable in the valuation of property. There is a current piece of legislation that's been proposed, Senate Bill number 187, and that states that members of the PTABOA must be a resident of Indiana. Currently, there's no residency requirements, but this legislation would make it a requirement for PTABOA members to be a resident of the state. For a 3-member PTABOA, at least one of the members appointed by the council must be a level 2 or 3, and then the 2 members appointed by the commissioners, at least one must be a level 2 or 3. Like the 5-member board, the county fiscal body and the commissioners may waive that requirement, especially in trying to find people to serve on the board. Sometimes they have to make that decision to waive that requirement, but that would be a local decision. And much like we saw with the 5-member board, members must be at least 18 years of age and knowledgeable in the valuation of property. For multiple county PTABOAs, it would, for the entire geographic area, it would see, you can see it would be, if there were 3 members, or 5 members, in terms of the political affiliation for those members, and the ordinance that's passed by the counties must specify the numbers, specify the members of the multiple county PTABOAs. Same, excuse me, the same requirements in terms of being at least 18 years of age and knowledgeable in the valuation of property would be applicable for multiple county PTABOA. There are a few people that may not be members of a multiple county PTABOA, and those include an elected county official, an employee or of a county or township that is in the geographic area, and then an appraiser. And by this appraiser, we're not talking about fee appraisers, but we're talking about those that may be an assessor appraiser certification. In terms of the compensation for the members of the multiple county, that would be determined by the fiscal bodies of each participating county. And the county that has the greatest population would be the county that would provide the administrative support to the multiple county PTABOA. And just a reminder, the county assessor serves as a non-voting member of the PTABOA, be it a 3-member, 5-member, or if we're multiple county PTABOA, the county assessor serves as a non-voting member, but as the secretary for the PTABOA, and the county with the greatest population would provide this administrative support. There is a provision in the Indiana Code that states that the PTABOA shall have an annual meeting. It doesn't specify when that is. Some counties will do it, say here we are in the middle part of January, they may do it in the first month or so of the year, but if a county decided, hey, we wanted to do it in July or October, that's their prerogative, but they must do it, must have an annual meeting at least during the year. You can see there's also publication requirements for the general meeting. And at the general meeting, the PTABOA meeting, the annual meeting, that's typically when a chairperson would be selected and any rules or procedures would be decided in terms of how and when the PTABOA is going to meet. In regard to the appeals side of things now, as far as preliminary hearings go, the assessor shall schedule a preliminary conference with the taxpayer at a time that's convenient to the taxpayer. A question came up the other day is, should this preliminary conference be held in the assessor's office or should it be held at the property? Typically, those preliminary meetings are going to be held at the assessor's office. It's not a requirement, but it just, from a central location, it makes sense to have the meeting at the assessor's office. But there may be a case where taxpayer may not be able to get to the assessor's office, and maybe they do hold it at the subject property. Or there may be situations where, think back to the COVID pandemic, where maybe the informal hearing, the preliminary conference is done via Zoom or in a Teams meeting, but the assessor should try and schedule a preliminary conference to meet with the taxpayer to go over that taxpayer's appeal. And prior to that preliminary conference, the taxpayer and the assessor should exchange the information that they're each is going to be relying on. So, in other words, we don't want to have any hidden surprises, so to speak. So, if a taxpayer has an appraisal done, they should provide a copy of that appraisal to the assessor's office. The same way if the assessor had an appraisal done, they would want to share that information with the taxpayer. If after the preliminary meeting, but before the PTABOA hearing, if there's additional information that should be given to the other party. There's no time frame for when this information is to be shared. Is it a day before, a week before, 15 minutes before? I would suggest try to get the information, if there is additional information, to the other party as soon as possible, so they have as much time to review the information versus being surprised with it at the PTABOA hearing. What happens though if somebody shows up at the PTABOA hearing and they provided information, then the party that receives it has the opportunity to look at it. The party that received it could ask for a continuance of the hearing, or they could say, we know what's here, and then we'll waive that continuance. But it would be up to the receiving party to either ask for a continuance or to waive that continuance. Regardless, the PTABOA is required to give the taxpayer at least 30 days notice of the hearing. If the taxpayer and the assessor agree on a shorter period, that's fine, but they should be given at least a 30-day notice. If more than 180 days have passed since the date the notice of appeal was filed, and the county PTABOA has not issued a determination, a taxpayer may, not necessarily shall, but a taxpayer may initiate an appeal with the Indiana Board of Tax Review. We've had this question come up frequently from taxpayers saying, hey, I filed my appeal back in May, and here we are, January, and I have not heard or seen anything from my PTABOA. What can I do? It would be up to the taxpayer how they want to proceed, but since 180 days had expired since the appeal was filed, they would have the right to file an appeal to the IBTR. They could wait for the PTABOA to make a determination, schedule a hearing, but they do have the right to file an appeal if 180 days has passed since they did file their appeal. In regard to other things, you can see a taxpayer and the assessor may enter into an agreement and say, hey, we want to skip the local PTABOA process and go straight to the IBTR. That's, if both parties agree, that's their prerogative. They can do that as long as they agree to waive the determination. If they do that, then they are also stipulating to the assessed value as determined by an independent appraisal. So there's pitfalls or shortcomings, but also potential benefits of maybe going straight to the IBTR versus handling it at the local level. Confidential evidence or information. So certainly, especially as we get into income producing properties, there could be confidential evidence such as income and expense information. And since this is a public hearing, if the PTABOA does receive confidential information, they are to maintain the confidentiality of that information. The PTABOA could go into an executive session to discuss the confidential information. However, the hearing should not be stopped just to start an executive session of the PTABOA. And the process for executive sessions, you can see the Indiana Code provision states that for discussion of records classified as confidential by federal or state statute. During the executive session, the PTABOA may not take final action. So they can meet in executive session, talk with the taxpayer regarding, say, income and expense information, but they may not take any final action in the executive session. And because the PTABOA is subject to the open door law, there are certain provisions that must be made or adhered to. First is the PTABOA is a gathering of a majority for the purpose of taking official action upon official business. And notification, public notice must be given at least 48 hours prior to the meeting. So we talked about a 30-day time frame to notify the taxpayer of their PTABOA hearing, but in terms of notifying the public, that must be given at least 48 hours prior to the meeting. And that can, some counties will post the meeting notice on their office door. Some may post it on their website, but there must be at least 48 hours notice prior to the meeting. So what is official action of the PTABOA? It's a fairly broad term, but typically would include the hearings and deliberation by the PTABOA. It could also constitute receiving information, deliberations, making recommendations, establishing policy, making decisions, and taking final action. In regard to how much are the PTABOA members paid or what's their compensation, this is a policy. These are things that's cited at the local county level. Some counties will pay more than their neighboring counties, possibly, some maybe less. I'm aware of at least one county where the PTABOA members have voluntarily decided to waive their compensation and give the money back to the county. But that's not a requirement, but that's something that at least one county that I'm aware of does. The county council is responsible for fixing the rate of the compensation, and the county assessor is acting as a secretary to the PTABOA, will keep an attendance record and then certify the number of days to the county commissioners, be it the PTABOA met one time during the year, or sometimes, especially during the busy, after the appeals are filed in May and June, during the summer months, maybe the PTABOA is meeting once a week. Some PTABOAs, based on the number of appeals they have, maybe they meet year round, like the third Friday of the month or whatever their policy is. So the number of days would be certified to the county commissioners. Some counties have found that they need additional help, and so they hired field representatives to help acting as hearing examiners, or just in terms of helping with the board research property tax appeals or looking at the properties. If a board does hire a field representative, they must be a level 2 or a level 3 assessor appraiser. And if they are hired, that the number of people and the compensation of these representatives and examiners would be appropriated by the county council. It's not a requirement, but some counties, especially larger counties, may have the need for a field representative. The field representatives and examiners are afforded the same powers, and we'll talk in a minute about the powers of the board. And key thing here is that the representatives and examiners shall report their findings to the board in writing. So typically they would have an appeal, they would make their recommendations, documentation, and provide that to the board. The board then can say, we accept accept the information and the recommendation of the board, or they can say, well, we don't necessarily, and we're going to hold further hearings and take additional evidence. But the board is the one making the final decision on each matter. So even though a representative may make a recommendation, it's still up to the board to make the final decision. So the powers of the PTABOA, they have the power to subpoena witnesses. They have the power to examine witnesses under oath. They have the power to compel witnesses to answer its questions relevant to the assessment of the valuation of the property. And they also have the power to order the production of relevant papers, be it sales information or income and expense information, whatever they need or deem relevant for that case. So here we are, January 22nd. A week ago, January 15th was the deadline for the appeals annual report to be filed by the PTABOA, typically done by the assessor, to the DLGF and the Legislative Services Agency through our Gateway program. If you have any questions about filing the report or what goes on the report, at the end of our presentation, I'll provide my contact information, and please feel free to reach out to me. But this report shows, say, for a report filed by January 15th, it would show all of the appeal activity for calendar year 2024, such as the number of appeals filed, how many are still pending, how many were resolved in favor of the taxpayer, how many were resolved in favor of the assessor, things like that. And this information is available to anybody. They can go on our website, go to Gateway, and they can look at all 92 counties and see how many appeals were filed. There have been some legislative changes in regard to the PTABOA and also to the appeals, and we'll talk about the first one is last year, House Enrolled Act 1328 specified that the terms of the PTABOA members are to be staggered, and this is applicable to both 3-member and 5-member boards. The issue is that the term for the PTABOA members is 1 year, and so currently in our House Bill 1427, which is the DLGF sponsored bill, Representative Snow, we have a proposal in there to change the term from 1 year to 2 years. That way we are able to stagger the terms. And coincidentally, that House Bill 1427 is being heard right now in the House Ways and Means Committee. So it is quite literally happening as we speak, so to speak, in terms of potential changes in the legislative process to address the staggered terms from 1 year to 2 years. So what are some best practices, be it for appeals or be it for PTABOA hearings, PTABOA actions? What are some best practices? First is the golden rule. Treat one another as you'd want to be treated yourself. And that means treating taxpayers, assessing officials, whomever. But if you're a PTABOA member, treating the other person how you'd want to be treated. The PTABOA meeting is not a trial like we think of a judicial trial per se. But if you're a PTABOA member, you should conduct yourself like a judge would. There have been a few changes in regard to the burden shifting statute, and this is who has the burden of proof. So in 2022, the General Assembly passed Indiana Code 6-1.1-15-20, and that basically provides that if a property's assessment increased more than 5% over its assessment for the prior tax year, the assessment loses presumption of correctness, and the assessing official has the burden of proof. However, if that assessment increased by more than 5% due to new construction or substantial renovations or zoning changes or uses, then that burden shift would not be applicable. But if it increases more than 5%, then basically the county assessor or the township assessor would have the burden of proof. In regard to the actual hearing, we talked about that the PTABOA shall give at least 30 days notification to the taxpayer in terms of the date, time, and location. And then also we talked about that if the taxpayer files an appeal and 180 days has passed since the taxpayer filed their petition and nothing has been done, a decision has not been made, then the taxpayer does have the right to file an appeal with the IBTR. In some situations, there may be a need to ask for a continuance. Perhaps there's a physical issue that happens, or there's a scheduling conflict, or something arises that the taxpayer may not be able to make the PTABOA hearing. If they do request continuance, they should have it in writing, and it must be filed at least 10 days before the hearing. If the request is granted, the PTABOA would then reschedule the hearing. Question has come up before is, well, how many continuances could we or should we give? Certainly, I think one is appropriate, but if a taxpayer has multiple requests for a continuance, say 2 or 3 requests, you may want to reach out to the taxpayer and find out why are they having difficulty, getting to the meeting, and maybe you have to work around that person's schedule and schedule the hearing that is conducive to their schedule. But to have multiple requests for continuances should probably not happen, but it could happen. A taxpayer can withdraw their appeal. Sometimes taxpayers will file a protective appeal, so to speak. They want to make sure they get their appeal filed timely, and then after they file their appeal, they find out that, hey, maybe I was wrong and the assessor was right, or maybe they decide I don't want to pursue the appeal. That's fine if they want to withdraw it, but they must file it in writing at least 10 days before the hearing. If the taxpayer does file withdrawal of their appeal, then the PTABOA would issue a final assessment determination indicating that there's no change in the assessment. The key thing here is that the taxpayer does withdraw their appeal, they waive their right to appeal to the IBTR. So a taxpayer couldn't waive their appeal at the local level and then turn around and file an appeal at the IBTR. In terms of the continuance, if there is a hearing continuance, then again, mention at least must be done at least 10 days before the hearing and then rescheduled accordingly. So in terms of hearing protocol and procedures, what do we do or how do we do it? When do we do it? Why do we do it? Again, these are going to be local control determinations in terms of the structure of the hearing, but certainly the taxpayer must have the opportunity to present their testimony and evidence. The assessing official or the auditor, if we're dealing with a situation such as a exemption, deduction or exemption claim or deduction claim, and the auditor is involved, the assessing official or the auditor would have the opportunity to present their testimony and evidence. And both sides then would also have the opportunity to question the other side in regard to their documentation, their testimony, their evidence. The PTABOA may adjourn and then continue the hearing to make a physical inspection. We'll talk about this in a minute or two in terms of making a physical inspection or to consider the evidence. It's up to the PTABOA. Some PTABOAs will make a determination right then and there. Others will take it under an advisement and come back and meet at another time to make their determination. Again, this is going to be a local decision by the PTABOA. It's based on a majority vote, based on the evidence presented. and then the PTABOA shall issue a written decision. We've talked about it a couple times now that the taxpayer has the right to file an appeal if a determination has not been made within 180 days since the filing of the appeal. Once a determination is made by the PTABOA, the taxpayer has 45 days to file an appeal with the IBTR if they so decide. So what happens if you have a taxpayer or a tax representative that files their appeal, the appeal hearing is scheduled, and they fail to show, and they did not ask for a continuance or anything like that? The assessor may, it's not a shall, but the assessor may impose a $50 fine. If the assessor does impose the $50 penalty, the taxpayer may appeal to the IBTR or to the Indiana Tax Court. A key thing here is the penalty will not be added as an amount owed on the tax bill. So this would be billed separately to the taxpayer. So they would not see the $50 penalty on their tax bill or tax statement, but they would receive a tax bill in the mail. I'm aware of some counties that have decided to do this, and I think they've had some success trying to mitigate those taxpayers that or tax representatives that may file an appeal and just strictly don't show up, and the assessor is taking a lot of time and effort to get their case ready for presentation, and the taxpayer or the tax representative no-show. Other counties have said it's not worth it, the hassle of doing the penalty. So it would be a local control decision whether or not they wanted to impose a $50 penalty. So who can represent taxpayers? Well, certainly the taxpayer can represent themselves. A taxpayer could also have an attorney, or if they want to have a certified tax representative. A couple of years ago, legislation was passed that the property owner may appoint a relative to represent them before the PTABOA or the DLGF, and that's quite all right. The relative is not required to be a certified tax representative. However, the relative, if a property owner appoints a relative to represent them, they may not represent the property owner before the IBTR. So who is or what constitutes a relative? You can see, talks about under the Indiana Code, talks about being a spouse, a parent, a child, a sibling, uncle, aunt, nephew, niece, grandparent, grandchild. All those definitions would be applicable to a relative. So what is a prima facie case? And if you're a PTABOA member, how do you decide a prima facie case has been made? So in other words, how do I decide or know that the person, the taxpayer or the assessor defending the assessment, how do I decide that they've been able to make a case, one way or the other? And it's going to be based on the evidence and documentation and circumstances for each property. And if you're not familiar with the Indiana Board of Tax Review, they do post all of their decisions on a monthly basis. You can go to their website and go to their decisions link and type in either a name of a property owner or type in a subject like golf courses, for example, and you can see all the decisions that have been rendered by the IBTR on that subject or for that taxpayer or that year. The Indiana Tax Court also publishes all of their decisions online, so you can go through and read decisions and see, what cases or what information has been brought up in successful or not successful appeal hearings. Did a person have an appraisal done? Did they go through and have income and expense information presented? So looking at those types of resources could help determine, hey, this is applicable to our situation. It's similar, and maybe I can take something from those decisions and have it applicable to your decisions that you make. So What if you're an assessor county and you're having problems finding qualified individuals to serve on your PTABOA? And can your prior assessor serve on the PTABOA? Well, in some situations, some counties will, if they're having problems finding people to serve on the PTABOA, may elect to go from a 5-member to a 3-member board. If that's not suitable or that's not applicable or appropriate, there's always a possibility that the department, or excuse me, that the county assessing official, former county assessing official or township assessing official could serve on the PTABOA. We're not aware of any statutory provisions that would prohibit it. However, from just a court of public perception perspective, it may not look good. If I'm a taxpayer and I file an appeal and I go in and I see the former assessor sitting on the PTABOA, I may be thinking to myself, well, I'm not going to get a fair shake because they're going to automatically vote in favor of the assessor. But there's nothing that would prohibit that from happening. There is a prohibition of a former assessing official, be it an elected official or an assessing deputy. They cannot serve as a tax representative in their former jurisdiction. So if a county is having a difficult time finding people to serve, a couple other things county could do. They could look to see are there members of other PTABOAs in surrounding counties that may be willing to serve on the PTABOA in your jurisdiction. Maybe reach out to realtors or appraisers to see if there's somebody that might be interested. And I'm aware of at least one county here in Indiana that has actually placed an ad or an article in their local newspaper advertising and saying, hey, if you're interested in being on the PTABOA, please contact the assessor's office. So a few things that the county can do if they're having problems trying to find individuals to serve on the PTABOA. Should the PTABOA visit the properties on appeal? This is obviously a local control decision, but if you do, you have to take into account that there may be time and budgetary constraints. So you'd be paying perhaps, a mileage reimbursement to the PTABOA members to go. And if there's 2 or 3 or 4 or 5, however many PTABOA members going to physically visit the property, going at different times and money, it could add up to probably not being worth their time or effort to do that. So it would be local control, but you suggest that they probably not do that. Certainly with documentation such as aerial photography or photographs just from the taxpayer, GIS imaging, things like that. There are ways to view the property without going out, making a physical inspection of the property. Is the determination of the board based on a quorum, or is it of the whole board? And you can see the Indiana Code citation states that it's a determination made by the majority of the whole board. So what are some common issues or problems that show up? Well, the first is what kind of evidence? What are we dealing with evidence? And there are a few things. First is a USPAP compliant appraisal, uniform standards of professional appraisal practice. So if you have a taxpayer that comes in with an appraisal, the first thing you should be asking is that a USPAP compliant appraisal? Hopefully it is. If it isn't, then I don't know if I would give that appraisal much weight. Several years ago, legislation was passed that states that an appraisal is not required in the appeal process. So some taxpayers believe that if I file an appeal, I need to get an appraisal. That would be their decision. It's optional. Some may find having an appraisal will help their case. Others may say, I don't want to spend the time and the money to get an appraisal done. So it is not a requirement if you file an appeal to have an appraisal done. Some taxpayers may bring evidence such as the actual construction costs. If they do that, make sure they include both the direct and indirect costs. Indirect costs would be something like, say, attorney fees or building permit fees or architectural fees, something like that. Sale of the subject property is probably going to be the best evidence or documentation as long as it's an arm's length transaction. And an arm's length transaction means that parties aren't related. You don't have say a father selling to a son or cousins or whatever, and it was exposed to the open market. Sales of comparable properties. And this is where there's obviously some subjectivity. What is a comparable property? Is a one-story house comparable to a two-story house? Well, they both provide shelter, but what's motivating a person to buy a one-story house versus motivated to buy a two-story house? So when you're looking at sales of comparable properties, make sure that they are truly comparable. In terms of determining whether or not they're comparable, typically we get into appraisal and generally accepted appraisal and assessment practices. And you can see there are two court decisions that address this. The first one states a party must explain how the evidence relates to the appealed property's market value and use as of the relevant valuation date. And the second states the taxpayer must explain how each piece of evidence relates to the requested assessment. So taxpayer could come in and say, here's a comparable property, but they must be able to demonstrate or show here's how these properties are comparable. And if you read several IBTR decisions, that's one of the things that the IBTR stresses is that you'd have to be able to show how the properties are similar, comparable, or different. When evaluating the evidence, the assessor simply just can't say, well, I've reviewed it and I think it's a bunch of hogwash. I don't think it's valid. And they just can't come out with a blanket statement like that. They would have to come and say, here's why I disagree or don't believe that the information, the documentation, the evidence has merit. Maybe it's looking at income and expense information and they have expenses that they consider allowable and the assessors believes that they are not allowable expenses, or if there's something in an appraisal where maybe the appraiser used sales from a different part of the county that really should not be included, that they're really not comparable properties. So assessor simply just can't say, I disagree with it. You'd have to be able to provide reasoning for saying that you don't agree with their evidence or documentation. In regard to appraisals, I've talked about this a little bit. When you look at the sales that they use and the assessor or the appraiser makes adjustments to those sales, maybe the property under appeal has a swimming pool, but the properties that are used in the appraisals do not have a swimming pool, making sure that those adjustments are adequate. Or maybe a property that has an appraisal done has a detached garage, while the other properties that are being used, comparable sales, do not have garages. So you need to look at the appraisals closely and see what is being adjusted and how much are they adjusting it. And for income producing properties, looking at the income and expense statements, and this comes down a lot of times to looking at what are or not allowable expenses, what is the capitalization rate being used, things like that. There are some properties that have been legislatively have a special carve out or a special assessment methodology, such as golf courses, for example, are use only the income approach. So who can file an appeal? Well, typically it's the taxpayer of record on the assessment date, the January 1st assessment date. However, the IBTR has ruled that even though a person may not have owned the property as of the assessment date, if they're responsible for the tax bill, then they would have standing to file the appeal. Question we get frequently is, what happens if an appeal is not timely filed? Typically that appeal would be denied for not being timely filed, but in some situations the taxpayer may be persistent and they want to go ahead and file an appeal. The assessor could allow the taxpayer to file the appeal, but also with the understanding that they probably would not be successful because they were not timely in filing their appeal. For preliminary hearings, can the assessor have a set amount of time, say 15 minutes? Sure, and be a local control decision, but we urge you to be fair and consistent. So if you give one person only 15 minutes, unless it's a complicated case, to give the next person 15 minutes or a half hour or however much time is deemed necessary for that. Same way with the PTABOA hearings. Some counties will stipulate that they have 15 minutes per appeal or a half hour, whatever the case may be, but it would be a local control determination. Can the assessed value be increased if a taxpayer files an appeal? Typically, the answer would be only in those situations that if there was a change, say there is new construction or renovation or a zoning change or a use change, but typically that assessment would not increase if the taxpayer did file an appeal. There is another provision that could see a result in a change in the assessed value, and this is if the taxpayer and the assessor agree, and they have an appraisal done, and as long as the appraisal is done in accordance with USPAP, it is possible that the appraisal comes in higher than the assessed value. You can see more in terms of what happens if you have, say, competing assessment or competing appraisals, that the assessed value may not be lower than the lowest appraisal, and it cannot be higher than the highest appraisal value presented to the board. There's also a situation involving assessments with the assessed value less than $3 million. In terms of if there was an increase, you can see the Indiana code provision that addresses this. Or you can read the code citation, but you can read the different pertinent facts or things with this increase in the assessed value. And the key thing here is paragraph D. It says if the taxpayer who appealed an increased assessment under this section sells the property whose assessment was appealed for fair market value, notwithstanding that prior subsection, the assessor may reassess the property that was sold. So you can go back and read that thoroughly. Can a CPA file an appeal on a taxpayer's behalf on real estate? Typically, the CPA is going to be representing the taxpayer in a situation or a matter that relates to personal property only, and the CPA is not considered a tax representative. We get questions frequently about, when do I file the appeal? What's the time frame for it? Did I receive a notice of assessment of Form 11 from the assessor's office, or did I have to rely on the assessment notice being in the tax bill, the tax statement? So if the assessing official sends out their Form 11s, their notices of assessment by April 30th or before May 1st. So say, for example, 2025, if the assessor sends out their Form 11s by April 30th, 2025, the taxpayer would have until June 15th, 2025 to file an appeal. If for whatever reason the assessor does not send out their notices of assessment by May 1st, or they don't send them at all, then the taxpayer would have until June 15th of the following year. So say the assessor did not send out the Form 11s by May 1st, 2025, the taxpayers would have until June 15th of 2026 to file an appeal. Some Form 11s state that the taxpayer can only appeal the total value. In other words, they can't appeal only the land or the structures. And the IBTR has always said that, almost always said, that the taxpayers cannot appeal one or the other. However, in the past 2 years or so, they did analyze the appeal based only on the land or improvements only. So basically, when the assessor or the taxpayer is filing the appeal, that they're looking at the total value. So with that, Marlo, do we have any questions? Waiting for Marlo to get back on.
Barry?
Yes.
There are no questions in the chat here.
Okay. Let me advance the slide. We'll certainly hang on for a few more minutes. I do want to, if you do have any questions that you think of after this webinar is concluded, please feel free to reach out to me. There's my contact information. Also, you can go on our website. We have information about appeals and the PTABOA. You can reach out to your assessment division field representative if you have any questions. I do want to also remind people that this is the first of the year, first webinar of the year, but we will be having webinars each month. If you have any suggestions on webinar topics you'd like to see covered, please let me know. Or Jenny Banks, our communications director, or Marlo Hayden, please let us know what topics you'd like to see included in future webinars. Our next webinar for February will be on February 19th. It will be at 10 a.m. and 2 p.m. Indianapolis time, and it will be on Gateway Reports Overview. This certainly all the webinars are open to everybody, but if you have a particular interest in the various reports, we talked about for example, the appeal report that's filed through Gateway. I think it would be a very interesting topic to participate in the webinar on. So as Marlo mentioned at the top, this is good for 1 hour of continuing education credit, and we will be sending out the copy of the continuing education form and also a copy of the presentation, hopefully by the end of this week. If you know of anyone who may not have had the opportunity to participate in the webinar today, they still can go and watch and listen to the webinar at a future date and get credit for it. So, Marlo, do you have any parting words before we end the webinar?
No, I think you pretty much covered everything. And again, we'll have this information uploaded to the website for your viewing if you need to review it on Friday afternoon. Okay. And that's about it for us.
All right. Well, thank you very much for participating, everybody, and enjoy the rest of your day and stay warm.
Thank you, everyone.